embattled Congressman Matt Gaetz.
Matt Gaetz was one of the very few members in the entire Congress who bothered to stand up against permanent Washington on behalf of his constituents.
Matt Gaetz right now, he's a problem for the Democratic Party, and he can cause a lot of hiccups in passing of laws. So we're going to keep running those stories to keep hurting him.
If you stand for the flag and kneel in prayer, if you want to build America up and not burn her to the ground, then welcome, my fellow patriots. You are in the right place. This is the movement for you.
You ever watch this guy on television? It's like a machine, Matt Gaetz.
I'm a canceled man in some corners of the internet. Many days I'm a marked man in Congress, a wanted man by the deep state. They aren't really coming for me. They're coming for you. I'm just in the way.
The FBI has not even so much as spoken to me in regards to, I met with them the day before I was framed on a crime that I couldn't have committed back in 2017. They sat down with me. I had a death threat on me at the time. You know, I feel like through ultimately letting me drown in this and having proof that I couldn't have committed the crime, you know, I would like to see the 302 from that sit-down investigation. And I would also like to obtain the video recording in the conference room when the meeting was taking place, just to verify accuracy of the 302.
Video?
Oh, I know there were cameras present in the room.
I don't think we do not have, after a certain amount of time, that footage is erased, so I don't think we'll be able to obtain that.
What's the standard procedure for erasing the video?
Well, it does it automatically, so I don't know. That's up to our electronic technicians. They do that. They handle all of that.
But if you put my name into the system, I mean, they cannot sit down with me in a conference room and conduct a interrogation interview without there being a 302 created. You know, that's standard protocol. A 302 has to be created with an interrogation. So, I mean, it shouldn't be a matter of having to find the agent that met with me. It's just you know, where's the 302? He shouldn't have to make it up now. The 302 is already made up.
The agent who conducted the interview would be responsible for the 302. So I do actually need to know who spoke with you.
Right, but y'all don't have a centralized system?
Look, I'm not allowed to talk to you about our systems.
But this is in regards to something that was created for me, you know, and it's very important to know. I mean, that's another thing that I can FOIA if I need to, as far as where are these 302s going? Are they not created and put into a centralized system? Surely they're not kept in the hands and surely they're not kept in the hands of the officer that conducted the investigation. That would be ridiculous.
Sir, I'm going to do my best. If you want to keep on, you can, but I'm going to do my best to get you what you need.
You want to hear about one of the nastiest public corruption scandals? Agencies that are obstructing justice, destroying evidence, and turning a blind eye. Why is the county not wanting to comply on the public records request? You told me...
You probably have to ask the county, man.
You told me that if I submitted it, y'all would comply. That was the last time that we spoke.
I told you we'd look at it.
Shoveling. Proof of innocence. You said that we will comply. You said submit it and we'll comply. Why haven't I gotten... Why haven't I gotten... And shielding criminal activity. Really, Sheriff, is this really the position you're going to take? That it helped get a female Democrat mayor elected? Look, hey, y'all will not respond to anything. Any email, any public records request, anything. I want to know why. I am holding our county officials accountable for this. You know I was framed.
Robin Tannehill was sworn in on June 29th. She ran unopposed, and Tannehill says that allowed her to hit the ground running.
Over the past couple of years, I realized there were a whole lot of things I wanted to change, that I had to be in this seat.
That was one of your ringleaders right there. The attorney of my ex for the original child custody matter back in 2016, August of 2016. It was that time that my child was kept from me for approximately 2 months.
She says it's her community involvement that helped her prepare for the role she's in now.
You know, that doesn't really prove anything, but other than us as a community, we do need to get together and try to figure out our problem resolution here, because Matt Reardon is a danger to our society, and he's going to be a problem. Mark my words.
Who are you trying to protect? Is it that there's no call that came in, or is it that there's somebody like Robin Tannehill or Ray Tannehill that's on that call? I want to know. Why are y'all cowards? Why are y'all cowards? I'm saying I would like to, I'm trying to ask you. No to an interview. You said no to? Now back away from my truck. You do realize you're a public servant, right? Jared Bundren. Hey, I'm here to show you how to conduct a proper investigation. I would like to, do you have a minute? No, I don't. You don't? You received a call on May 24th, 2017. I would like the details of that call. Jared, I put in a public records request. Why are y'all not complying with the public records request? It's ridiculous, guys. You got the May 1st, 2017 arrest in front of that statue right there, where I was holding the state flag of Mississippi, standing on public property, not bothering a soul, just standing on this very pavement that I'm standing right now, holding the state flag of Mississippi. May 1st, Deputy Sheriff Timmy Pruitt pulled up. He asked me if I had a permit to be here. I told him that I had the First Amendment. You know, I am audio and video recording, Mr. Pruitt.
I don't care. You have a permit to be here.
The First Amendment, actually.
You have a permit to be here.
No.
All right, you gotta leave.
Why is that?
Because you're going to jail if you don't.
I'm going to jail just for standing out here and holding the flag.
Demonstrating.
I'm a Marine Corps veteran. I'm a patriot. I'm a 3%er. I took an oath at the end of 2007 to uphold and defend our Constitution from all enemies, both foreign and domestic. My oath had no expiration date. Nowhere in the military oath is there an expiration date that says that this oath is only good until the time of your service ends.
Yep. You have to leave.
Okay, where does that supersede? Let me just. Can I just ask you? Can I ask you a question?
I'm gonna ask you one more time to leave. If not, I'm gonna get you to jail.
His uniform was a little bare that day. He had forgotten to put his badge back on before coming out. Took about 7 steps off, and I turned around to ask him what his badge number was. That infuriated him because it made him look horrible. Okay, I'll leave and take this straight to my attorney then. That's you can't threaten me with my First Amendment rights. Hey, I'm going to tell you right now, Mr. Pruitt.
To leave. 1.
Said he is ass backwards. Ass backwards. Y'all see that? Hey, what's your badge number, by the way, Deputy Pruitt? No, I'm not. I'm leaving. I was asking you. I was arrested when I asked him what his badge number was. It infuriated him. He took me to the jail. I maybe was in the jail for about an hour before I posted bond. I grabbed my state flag. My car was parked right here on the square still. And I decided I was going to take a victory lap and walk from the sheriff's department with my state flag back to the square. And I did a victory lap around the square, holding my state flag, proudly holding my state flag. Because I knew what I did was not wrong. Even by the sheriff's department's own admission, and through multiple agencies, news agencies, I was arrested for holding the state flag on public property. Chain of events happens after that. I go to New Orleans, go stand up for the monuments under attack. I come back May 7th. May 8th, I have court the next day on a child custody hearing. I meet with my attorney for a lot of the day. I end up doing a countersuit against my ex, and I get the bright idea to go and serve her attorney. Oh, it was epic. Awesome. Hi, is Mona here?
I'm Mona.
Hi, Mona.
You're not welcome here.
All right, I just wanted to say you are hereby served.
Actually, no, you have to serve it with legal process.
Well, you're hereby served.
Hi, everybody.
What do y'all think about that? I've got a message for Sheriff Joe East. After a year's time of assisting and trying to make me somebody that I'm not, after like 17 police reports over the last 4 or 5 years from Liz Crowder, after the never-ending evidence of criminal conspiracy that has made its way to the surface, after all the time that's been lost, after all the time that I lost with my daughter, all the time that the Sheriff's Department has lost, that they could have helped other people that truly needed assistance, but instead want to continue feeding into the hands of Liz Crowder, taking more reports that pan out to be more false reports. At some point, refusal to take action would have to make me seriously pose the question of if the Lafayette County Sheriff is a competent position for you to hold. Say that for a reason. Because some way, somehow, regardless of having audio evidence, video evidence, you name it, this county will find a way to try to pin something else. Because it never ends. They will take whatever lies and bullshit that Liz Crowder comes up with to justify her reason for keeping my 6-year-old child from me, when at the end of the day, the number one reason is to influence ongoing legal proceedings. Something that it's no new claim. None. She's just dumb enough to continue repeating it. And the Sheriff's Department is clearly complicit enough to continue taking reports instead of shutting her the hell down.
42 U.S. Code 1985. Paragraph 2. Obstructing justice, intimidating party, witness, or juror. If 2 or more persons in any state or territory conspire to deter, by force, intimidation, or threat, any party or witness in any court of the United States from attending such court, or from testifying to any matter pending therein, freely, fully, and truthfully, or to injure such party or witness in his person or property on account of his having so attended or testified, or to influence the verdict, presentment, or indictment.
I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the Sheriff's Department. I'm here at the Sheriff's Department.
Or if 2 or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection to the laws.
You will go to jail for disorder.
I'm not being disorderly. I'm moving my car. I'm moving my car. I was moving my car. Ah! Ah! I said I was moving my car. Oh! Stop! Ah!
Paragraph 3. Depriving persons of rights or privileges. If two or more persons in any state or territory conspire to go in disguise on the highway or on the premises of another for the purpose of depriving, either directly or indirectly, any person or class of persons of the equal protections of the laws, or of equal privileges and immunities under the laws, or for the purpose of preventing or hindering the constituted authorities of any state or territory from giving or securing to all persons within each such state or territory the equal protection of the laws, or if two or more persons conspire to prevent, by force, intimidation, or threat, any citizen who is lawfully entitled to vote from giving his support or advocacy in a legal manner toward or in favor of the election of any lawfully qualified person as an elector for president or vice president, or as a member of Congress for the United States, or to injure any citizen in person or property on account of such support or advocacy in any case of conspiracy set forth in this section, if one or more persons engaged therein do or cause to be done any act in furtherance of the object of conspiracy whereby another is injured in his person or property, or deprived of having and exercising any right or privilege as a citizen of the United States, the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators.
Matthew Reardon. Mr. Reardon, I'm going to give you a warning one time and one time only. The next time you call up here, the next time you give anybody in my staff a hard time, I'm going to have you arrested for contempt of court. But not to come up here, when you call up here, you ask for me to rate it.
Your Honor, how did I do that?
Be quiet, sir. I understand you want to discuss something with me. Let's hear it. What do you want to discuss with me?
I was simply trying to inquire on the outcome of my ex. She falsely accused me of rape. You have created a monster.
Please take him on back. Take him on back to the back. Go back, sir. I'm going to hold you from contempt of court. Take him on back.
Your Honor, I was just trying to address this.
All right, sir, let's go. You want to go on your own?
Your Honor, please. My wife is outside. My wife's outside. My wife is outside. So which one?
I don't see a single thing that I did wrong there. Not a single thing. I think even when the judge got so far out of line, I still composed myself, considering the circumstances in a very well way. And I know that I wouldn't have a problem in the world convincing every last juror of my innocence, his extreme guilt, and ultimately the liability that falls back on the city of Olive Branch. I'm sick and tired of this lawlessness going on. I'm sick and tired of not being afforded equal protections under the law as guaranteed by the 14th Amendment of the Constitution. My rights over the last 3 years have been completely shredded, and nobody seems to give a shit. So here's your opportunity to fix the problem, to show that you want to do something to fix the problem. Or I'm going to fix it. Mayor Phillips, Mr. Dye. As a prior resident of Olive Branch, and the love for Olive Branch that my small family did share, It pains me to be typing this letter to you. Yesterday, on the 19th, I dealt with the most abominable, putrid of dealings and treatment by your municipal judge, Leslie Shoemate. That in itself is an upgrade for the complete lawlessness, lack of moral turpitude and integrity, and sharp, hard turn away from the Constitution and expectations of a functioning society. This type of reprehensible behavior by any government employee should never be tolerated. Yet it's become a common reality that I've witnessed more and more over the past several years, and especially when I decided to embark on my inner calling to document and produce in the live, ongoing documentary series, Riding With The Outlaw. I am a Marine Corps veteran. I swore an oath to my country to uphold and defend its Constitution against all enemies, both foreign and domestic. And the clear, cutthroat attack by this lawless municipal court judge in Olive Branch today pretty much undercut everything that I've seen and documented. It was an extreme abuse and fissuring of the judicial gavel, a permanent staining of the robe in which he wears, most certainly a tipping of the judicial scales, and a sharp declaration of war on our blended constitutional republic / democracy. The founding fathers of America, who declared our independence, are rolling over and over in their graves. The same ones whom outlined and emboldened our basic human rights of life, liberty, and the pursuit of happiness, and composed our Constitution, which has been the foundation that has set and molded America as the last truly free nation in the world, governed by laws meant to extend to all individuals and especially to protect all, especially naturalized citizens. In my time of dedicating myself to my country, and in my 33 years, I know of one Constitution, one set of laws, not two. This judge is not above the law. He's not above the Constitution. And the treacherous mistake that he just made yesterday is definitely going to cost Olive Branch. Judge Shoemate is a danger and a liability to the city of Olive Branch. He is a tarnish on the good name. I trust to it that Mr. Mayor and Mr. Dye will see to it that Judge Shoemate is relieved of his duties as municipal court judge of Olive Branch. All I've asked since the beginning was for equal protection of the laws, for the laws to be applied evenly. And I don't think I'm asking too much. My name is Matt Reardon, and I am the Oxford Outlaw.
In the Chancery Court of Lafayette County, Mississippi, petition for permission to interlocutory appeal to the Mississippi Supreme Court. Pursuant to Rule 5 of the Mississippi Rules for Appellate Procedure, Matthew Reardon, the respondent and defendant in the above captioned cause, files his petition for permission to interlocutory appeal to the Mississippi Supreme Court. Movan states that this petition is filed in good timing and most certainly with good merit, based on grounds for which relief through an interlocutory appeal may be sought.
Mobant would affirm that he has continued to sustain repetitive injuries at the baseless, frivolous, and vindictive hands of the petitioner, the petitioner's legal counsel, along with the state of Mississippi. Mobant states that each motion brought before this court has been prejudicially ignored, with preferential treatment shown to the petitioner in this cause the entire time, despite the fact that petitioner has had a history of filing false reports, and this very cause will show the furtherance of petitioner's continued behavior, which is not only morally incomprehensible, but in fact rises to the level of criminal conduct by flagrant and uncaring violations of Mississippi Annotated Code 97-7-10, fraudulent statements and representations, along with Mississippi Annotated Code 97-1-1, conspiracy, which the state of Mississippi has refused to acknowledge, condemn, and deter, despite the petitioner meeting literally every criteria of the statute needed for an indictment by a grand jury. Yet through what would easily appear to be culpable negligence at the hands of state actors acting under color of law, she has continued to get away with the intentional infliction of injuries upon the respondent and movant, and this court is further feeding into it by immorally changing a standing order when absolutely no evidence was produced and court proceedings delayed. Mobant further demonstrates the preferential treatment shown through his filing of a motion to dismiss or in the alternative to transfer venue, filed 11/16/2020, on the basis that venue, while jurisdictionally is proper, is in fact improper at the Chancery Court of Lafayette County, Mississippi, due to reasons of constitutional law, equity sought in counterclaims by the respondent due to the injury sustained, zero evidence produced up front as a way of justifying 9 months of contempt in violating a visitation order and a jury demand by the respondent movant for these reasons stated.
I don't know what part of, equal protections of the laws being afforded, how that doesn't directly, what all's gone on is exactly the definition of 42 U.S. Code 1985. The conspiracy to deprive another of their civil rights, and then the successful deprivation and continued deprivation. There couldn't be a more matched up scenario than what this thing is.
But you're asking David Reichert and now me, it's an opportunity to appear before the board in an emergency fashion.
I want the board supervisors to give me some accountability and some assurance that as elected officials in the county where this all stemmed, that they are going to do their due diligence and getting to the bottom of the facts. And I understand that it belongs in court, but you know what? There needs to be somebody that is interested in true justice, and not an innocent Marine Corps veteran having his life destroyed. Do you realize I can't even get an apartment anywhere because I have the fake tag of stalker on me? I am immediately prejudged because of something that I didn't do, and something that, in order for me to get my freedom to support my daughter and try to get her out of the court system, I had to do.
Well, there's nothing we can do as far as board of supervisors.
I wish like hell somebody in the board of supervisors, the same thing would happen to them so they could see exactly how it feels to have their whole life destroyed. I had everything going, and my life was destroyed.
If you want to get on the agenda, actually come to the meeting and stand up and be heard. Whatever issue, whether it's mac and cheese or whatever, you have to have a board member sponsor you for the agenda.
And I think the message of the lifeguard standing by watching a child drown, I cannot wait to give that compassionate story to a jury, because that's ultimately what's happened here. Is there's been a ton of culpable negligence. Agencies that should have done something should not have been a part of the problem, that stood around and watched me drown like they were a lifeguard watching a child drown, and the onlooker is too far away to do anything to help.
If there's anything else I can help you with, let me know.
I
I appreciate it, David. My big thing right now, I mean, plausible deniability can't be asserted at this point. That's one thing I've made sure of is to completely note, everybody that I've reached out to with this major problem. And, I hope that, somebody decides to do the right thing. Because certainly, I didn't know about it. It's not gonna fly.
Well, good luck to you. I'm sure we'll be talking again soon.
Sounds good. Thank you, David.
Okay.
All right. Bye.
Let's crowd. Conspiracy. I got an hour and 20-minute conversation with her. Have you not listened to it, Joey?
No, I
I sent it out via email. Actually, I haven't published the full recording. I'll go ahead and I'll get that published for you. But, guys, I have tried over and over to get you guys to just enforce the law evenly. I pull up to her house on Father's Day weekend. I never called her. So where this charge of making harassing phone call, threatening phone call comes in, I have no clue. Nobody fact checked her to even see that a phone call came in.
charged it.
Yes.
Yeah. That's for her. She has the right to do that. It's like you have a right to side target with her.
December 28th, when I got thrown on the ground. I came up here because I sent you multiple emails about Liz Crowder filing false affidavits in court. That's it. The statute is filing a false instrument, and it falls under that. I know that the court ultimately it's up to them to hit her with perjury, but there are crimes that she's steadily committing. I mean, a year I went without seeing my daughter. She's back at it again. She's back at it again because you guys keep enabling. You feed into it. You take a report. That's why there's so many reports on me, like 17 just over the last 4 years. When's it going to stop? Well, what about the email, May 26th, that you sent out? May 26th, 2017, you sent out to the mayor. about the new proposed gun laws in Oxford. You were pushing to change. Isn't that a coincidence? The day that I get ambushed in Oxford, you sent an email out. No, it's not. Okay, if we're going to look at conspiracy as in a plot between two or more people, then yes. If we're talking about conspiracy from a standpoint of hocus pocus, just making stuff up, no. You sent an email that it's on the internet. It was on the internet because it was part of the agenda that was published on June 6th. I was supposed to speak right after you. After you spoke, you came back at the end of the meeting because there were 2 bullet points where you were supposed to discuss the new proposed gun laws in Oxford. And I think it's a coincidence that May 26th, the day everything happened, nobody ever wanted to look into Todd Lynch and the threat that he made, calling for the community to come together to do something about Matt Reardon. But, you know, my kids have been directly affected by this. I lost 4 houses over the last 4 years. It's not fair for me to be carrying around a fake tag, a felon and stalker, knowing that not only did I not commit the crime, but it was an impossibility to have been committed. Impossibility.
Let me say this. I appreciate you come up here. Don't come back in with the camera. Okay?
Yeah.
And all the stuff that you're talking about, it's an old case that you pled guilty to that in the court of law.
I just got diagnosed with bipolar. Y'all preyed on a mental illness of somebody that you tried to get. Right.
So that case is over.
However, before I pled guilty, the county was in violation of my due process rights guaranteed under the Constitution. So, I mean, does that really even make my plea valid? I think not.
The foregoing petition is in regards to the current ongoing criminal charge of disorderly conduct and resisting arrest, which are identified in this court under cause numbers 929-0609 and 929-0610, respectively. The plaintiff in this particular matter brought forth is Matthew Reardon, whom hereby petitions for a writ of mandamus and seeks relief from the trial court, trial judge, and ruling made on March 1st, 2021. Plaintiff states that the defendant judge, Mickey Avent, acted outside of his jurisdiction, of his office, and even authority in this particular situation in ordering that the plaintiff cease recording of proceedings brought forth in this court. The trial judge did so, citing Rule 1.03. The trial judge referenced the Uniform Rules of Procedure for Justice Court. Plaintiff stated on numerous occasions that he felt he couldn't get a fair hearing in the Lafayette County Justice Court due to events that have taken place over the past 3.5 years, all stemming from the crippling decisions made in this very court when Judge Carolyn Bell took it on herself to set plaintiff's bond at $150,000 on a felony charge levied against the plaintiff in May of 2017, which not only lacked probable cause, but deprived the plaintiff of his due process rights along with his civil liberties by setting bond in a punitive way, even when plaintiff asserted he had solid proof that he couldn't have possibly committed such crime. Plaintiff had assertively claimed reservations and worries that he had, including recently demonstrating how he feels that he's demonstrated Lafayette County officials and agencies denying the plaintiff of equal protections of the law, which are granted not only by Article 3 of the Mississippi Constitution and its Bill of Rights, but the federal Constitution, which plaintiff swore a lifelong oath to protect and defend. Plaintiff would vehemently affirm before this court that he has remained on the receiving end of repetitive targeting by way of preferential prosecution, which over and over has exceeded the threshold of malicious prosecution and even prosecutorial misconduct. Not only is this blatant to the plaintiff in this cause, but it should be blatantly clear to any onlooker, not only with this cause, but the other open causes filed in this court as well. When all evidence is assessed in November 2020, plaintiff was involved in a case in Olive Branch where he was charged with contempt despite doing exactly what he was asked to do by the court. Fortunately, the case was just dismissed on March 1st, 2021 due to plaintiff carrying a tape recorder which corroborated exactly that which the plaintiff claimed. The alleged false arrest is currently on file and pending before the U.S. District Court of Northern Mississippi, referenced by case number 320-CV-1 00327-DMB-JMV. It is reasons like this that the plaintiff feels it is a paramount need and one that each court should allow. In fact, plaintiff is of the impression that this is a request that should be looked at as an accommodation, and one that's no different than any accommodation afforded to Americans with disabilities under the Americans with Disabilities Act. The trial judge read off the title to 1.03 in the Uniform Rules of Procedure for Justice Court. However, after the title, nothing made sense to the plaintiff, and it almost felt to the plaintiff that this reading was being falsely read and presented to the plaintiff. However, Rule 1.03 states as follows. Use of cameras. The use of cameras, recording, or broadcasting equipment, or such shall be governed by the Code of Judicial Conduct. Plaintiff would state that not only does 1.03 lack any language that would bar the use of an audio recorder, especially in lack of a court reporter / transcriber. This in turn poses prejudicial and completely one-sided to the plaintiff, where everything is left up to hearsay in the absence of proof. Plaintiff requested to motion the court for him to be allowed to audio record the hearing and was immediately denied, further being told something to the effect of, "The rules are the rules." Plaintiff hereby quotes Rule 2.03, additional rules out of the Uniform Rules of Procedure for Justice Court, which states as follows. No rule of procedure, local or otherwise, shall be adopted without the approval of the Mississippi Supreme Court. Plaintiff would request answer from this trial court, and specifically the trial judge, as to if he and this court had approval of the Mississippi Supreme Court to establish such a rule that adversely can affect the outcome of a legal proceeding, and one which is clearly not spelled out in the reference rules of Uniform Rules of Procedure for Justice Court. Plaintiff would then jump down to Rule 3.01, applicability of rules, in the same referenced outline. Rule 3.01, rules of criminal procedure in justice court, are governed by the Mississippi Rules of Criminal Procedure. General rules are also applicable in criminal cases. When taking a look at the Mississippi Rules of Criminal Procedure, which just so happens to be the true governing doctrine, and examining the facts of this case, it would appear that the rights of the plaintiff on this motion have been affected in a way that could create a material breach of even more entitled rights of the plaintiff. Rule 1.10 of the Mississippi Rules of Criminal Procedure details recordation of proceedings where official court reporters are not provided. Any attorney of record or pro se litigant in a court which does not provide an official court reporter may record or have recorded any court proceeding by audio recording device or stenography. Any expenses incident thereto shall be borne by the party or parties. Plaintiff has attempted to raise multiple instances of irregularities and what would easily appear to be unscrupulous, immoral, and unlawful conduct demonstrated by deputies on site while arrest was made. Plaintiff will not concede his notion that this arrest was a targeted, unwarranted, and further unlawful arrest made with excessive force used, and all for the plaintiff commuting to the sheriff's department to communicate his grievances with Sheriff Joey East. Plaintiff has been denied access to the closest camera angle of arrest, which plaintiff wholeheartedly believes is an attempt to hide or cover up wrongdoings, and following plaintiff's assertions of not being afforded equal protections of the laws. As such, it is for these reasons listed that the plaintiff believes the idea of a fair and impartial trial is at an improbability and nearing an impossibility to the plaintiff. As such, duress is taken over. The plaintiff respectfully request answer from this trial court and the trial judge, along with a review of such from the Supreme Court of Mississippi. As plaintiff feels as though not having a court reporter, no jury, and no recording equipment potentially paves way to a constitutional crisis and has a habit of removing all fairness from a proceeding that should be comprised of fairness. Plaintiff also requests answers to why Lafayette County is refusing to produce the closest camera angle of the arrest and parked vehicle despite resistance on the matter. Plaintiff feels that this information is not privileged and is nothing more than the Lafayette County Sheriff's Department and Lafayette County officials yet again attempting to cover their tracks. Plaintiff hereby requests that any and all hearings in this court involving him be pushed back to allow proper response and adherence to request. If this court, the prosecutor, and the state of Mississippi
wishes to proceed on with this cause and not dismiss in light of the information brought forth, then plaintiff hereby invokes his right to a trial by jury of his peers, as guaranteed to him by the state and federal constitutions. Respectfully submitted this 2nd day of March 2021. Matt Reardon, the Oxford Outlaw. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to him. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the sheriff's department. You will go to jail for disorder. I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. I said I was moving my car. Oh, stop. Stop.
Matthew Oliver Reardon, the plaintiff, versus Olive Branch, Mississippi Municipal Court and the State of Mississippi, in cause number 320-CV-00327-DMB-JMV. This is a proposed amendment to complaint. The background of plaintiff and basis of complaint is as follows. Your currently pro se plaintiff is Matthew Oliver Reardon. Reardon is currently 33 years old as a United States Marine Corps veteran. The plaintiff witnessed a gruesome suicide in Marine combat training, which led him to self-medicating through drinking alcohol. Reardon is married. He and his wife Madeline parent and raise 3 minor children full-time, and plaintiff's minor child from another relationship every other weekend, in a perfect world. Reardon is currently unemployed and financially fatigued from having to fight 7 different court battles pro se concurrently, without the assistance of an attorney, nor the financial means to hire one, as he has had to file everything in order to prevent being time-barred, to appeal everything and effectively restore his life and what all had been taken from him on what he alleges was a false arrest and false imprisonment, stemming from a knowingly false charge that was conspired upon and acted upon by individuals in the government, law enforcement agencies, and courts. Plaintiff has only sought the equal protections under the laws of the state and congruent with the United States Constitution. After all, plaintiff made a lifelong sworn oath to uphold and defend the Constitution against all enemies, both foreign and domestic, to bear true faith and allegiance to the same, and to obey all orders of the President of the United States. That oath never expires.
42 U.S. Code 1986. Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses to do so, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such wrongful act, which such person, by reasonable diligence, could have prevented, and such damages may be recovered in an action on the case, and any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. And if the death of any party be caused by any such wrongful act and neglect, the legal representatives of the deceased shall have such action therefore,
and may recover not exceeding $5,000 damages therein for the benefit of the widow of the deceased, if there be one, and if there be no widow, then for the benefit of the next of kin of the deceased. But no action under the provisions of this section shall be sustained which is not commenced within 1 year after the cause of action has accrued.
This is Tony Geiger with the Attorney General's Pitches Office. How are you?
Good. How you doing, Tony?
I'm good. I was going to say, I sent you my email address. If you'll send that, what you're saying, send me a detailed email, and I'll send that to our investigative division for their review.
And can the state attorney general's office not even just pull the court filings? I mean, this.
We don't represent individuals. So what you would probably need to do is to secure a good legal counsel, is what I'd suggest.
Yeah, and you told me this last time, but that's bullshit, Tony, because you know what? Hey, look, crime doesn't discriminate as far as money. And
follow the state constitution, but I do agree crime is not good, and I hate it that you're going through this.
I know, but see, here's the thing. I've also done a year-long independent investigation. It's indisputable. So I know that all these crimes are being committed out in the open, that it's not that hard to see that's what's going on. I mean, you're telling me that I have to have money to have an attorney to do anything, and I'm telling you that's bullshit.
Well, you can send me that email, and I will definitely spend time investigating.
I will.
So you can go on our website, and you can go straight to our complaint form, and you can do it that way, and I will assure you they get it.
Yeah, I did that with the FBI, and guess what? They lost the record. So
they won't, because if you will give us a chance to do the right thing and send us, of course, I'm not saying what we'll do. I'm saying they will definitely use their due diligence.
Well, actually, Tony, there was one other thing. I just want to hear that Len Fitch is actually acknowledging the issue, because I've sure raised a lot of hell about it. No, I just want to hear that Len Fitch has acknowledged the issue, because I've sure made a big stink about it.
But you will put that on our complaint form, send it, or you can send me an email.
Okay. Does Len Fitch, is she aware of the issue in Lafayette County?
I don't know what issue you're talking about.
We spoke, and I gave you everything in detail months and months ago. But is she aware? Is she aware of the issue? Can you at least confirm?
It was your interpretation of the issue, and that's why I want to make sure if you'll send that to us.
Right, but is she aware of the issue?
If you send that to us, we will look into it.
I've gotten that too many times. Is she aware of the issue, Tony? Yes or no?
I'm not going to answer your question.
That's not a good job as constituent services.
I'm trying to help you.
I'm a constituent. I'm somebody that's been affected. I've been denied access to a forum. I've been denied access to the people that are supposed to police their own. Is she aware of the issue? Yes or no, Tony?
Send me your email, and you can also go on our website and you can file a complaint.
Okay. That's what I figured. The state of Mississippi's never given two shits about mental health, and they don't give two shits about doing the right thing here either. So,
NBI.
Season 3.
Yes, ma'am. I was calling to see if the NBI had any remarks or accusations of it being complicit in an ongoing scandal involving the Oxford mayor.
Okay. And what is your name?
My name's Matt Reardon.
Pardon?
My name is Matt Reardon.
Oh. Okay. And a phone number for you, Mr. Reardon?
662-812.
Yes, sir.
1613. I've called 5 times. This is the 5th time now. I've described the scandal to the T. I've produced unsurpassed amounts of evidence. At this point, the only explanation for the NBI not getting in touch with me like I've been told every time is that they are complicit in the scandal. And I'm making the direct accusation of the NBI being complicit in everything going on for the simple fact of they have neglected their own duties. They have allowed nonsense election fraud to go on. They have allowed an innocent citizen to stay framed that was part of of a election stunt, and they have refused to so much as even pick up the phone and talk to me. There's no other way of looking at it than the NBI is complicit in feeding directly out of the hands of the problem.
Plan for development. We are right now looking at the first draft of our...
Okay, sir. Well, I apologize that no one has called you back. I made that.
I know it's your organization that's corrupt, though. It's not you. You've passed the message along, but corrupt individuals in your organization have seemingly propelled and allowed this problem to go on and have fed it with gasoline.
I think that...
Okay, well, sir, if you have any issues with our agency, it can be reported to the Attorney General's office.
Yeah, the Attorney General's office is just as complicit because I've reached out to them. I mean, for nobody to even look at the evidence that's right in front of their very eyes just says a lot of the status quo of our country and its agencies. And it's absolutely sickening.
Many different roles from President of the Chamber of Commerce.
Okay, sir. Well, I apologize. There's nothing that I can do to help you other than providing this information to someone to have them return your call. Now, at what point they do that, I have no control over that, sir.
I understand that, but I'm just all I'm saying here is that this is something that when it blows up into a bigger problem, the finger pointing is going to be directly at the agencies that did not do anything about it. That were begged to intervene.
Okay. Well, let me get this message. Let me verify I have your number: 662-812-1613.
Correct.
Okay. I will pass this message along, sir.
All right. Thank you.